Thank you, Mr. Chairman. Thank you, Mr. Menashi. Mr. Menashi, you're a lawyer, and a good one. And as a good lawyer, you know that lawyers have clients. In fact, lawyers can't do what lawyers do without representing a client. One can engage in the teaching of law, one can expound upon the law, but in order to actually practice law, one needs a client. There are duties of confidentiality that accompany the attorney-client relationship, and you understand the sacred nature of those duties. And in fact, the duty of confidentiality extends not only to revealing the content of discussions discussed, but also often, necessarily, unavoidably extends, does it not, to the topics covered with a particular client.
Senator, that's right. So oftentimes consultations with a client are subject to confidentiality, even topics.
Therefore, unless the client has relinquished that privilege as to the issue at hand, as to what topic the lawyer has addressed with the client, the fact that a conversation has occurred, the fact that a lawyer has been employed on a particular topic is itself privileged. Is that right?
That's right, Senator.
In fact, there are a whole lot of standards of professional responsibility that govern a lawyer's handling of confidential information, including information related to what topics a lawyer has addressed with a client. Many of those rules are amorphous, but many of them have been summarized in Rule 1.6 of the ABA Model Rules. ABA Model Rule 1.6 covers the confidentiality of information. And it talks about the fact that a lawyer can't reveal information relating to the representation of the client without the client's consent. Now, there are some exceptions to this, and Rule 1.6 goes through those exceptions. Those exceptions are quite narrow. They relate to things like imminent harm or risk of death to a third party, or to litigation between the lawyer and the client, or to a lawyer's desire and effort to figure out whether the lawyer has complied with ethical rules applicable to the lawyer. As far as I can tell, there is nothing in Rule 1.6 or in anything else accompanying the rules of professional responsibility regarding the lawyer-client relationship that gives you open-ended discretion to decide to disregard the duty of confidentiality that you owe to the President of the United States, to the White House, or to any other client in this circumstance. And so that's why, to some of my colleagues who have criticized you for that, I guess my response is twofold. Number one, remember that Mr. Menashi is in fact a lawyer who has clients. Number two, to the extent that you've got a question regarding which matters he may have worked on, if Mr. Menashi is not authorized to speak to those today, which we're told he is not, you can raise those in question for the record, giving Mr. Menashi the opportunity to confer with this or any other client and to secure that client's permission if that client chooses to grant the permission. That's the appropriate way of going about it. It is not appropriate to beat up Mr. Menashi on the basis of a permission that he has not been granted to reveal confidential information. Wanted to ask you about something you wrote a few years ago in a review of Robert Kagan's Warrior Politics, Why Leadership Demands Pagan Ethos. You discussed a State Department policy that provided that quote-unquote advocacy of terrorism would not automatically disqualify a person from receiving a visa, and suggested that the policy was misguided. Here's what you wrote. The civil libertarian impulse that drives such policies is of course salutary, but civil liberties mean very little when the state is unable to protect them. At some point, one is faced with a choice between liberty and order, but between liberty with order and anarchy without either, as Justice Jackson once observed, close quote. As you know, the quote is from Justice Jackson's dissent in Terminello versus Chicago. Notably, while Justice Jackson's quote is a now famous one, it's clear that the outcome he preferred in that case was, and I think remains, inconsistent with the court's First Amendment jurisprudence. In other words, Justice Jackson's appeal in that case to order and security would in that case have resulted in a direct infringement on constitutional rights. So can you tell me to what extent is the role of the circuit judge to determine when practical wisdom should temper the civil libertarian impulses enshrined in our founding documents, either in the First Amendment or otherwise?
Senator, yes, I appreciate the opportunity to clarify. So the essay to which you refer is something that I wrote before I even attended law school, let alone worked as a lawyer. So I would not understand it to be developed legal view on the status of any particular precedent. In that essay, which was a review, as you mentioned, of a book that had advocated sort of more tough tactics in the war on terror, I addressed some of those concerns about whether tactics should be tougher or not. But the bottom line and the main point of that review was ultimately that we should not lose sight of our moral aims in prosecuting the war on terror or dealing with civil liberties at home. So even though the essay sort of identifies issues where it may make sense to take note of tough realities on the ground, my bottom line, I think as I said directly, was we should not lose sight of our moral aims, that power that serves only itself is a monstrous thing. And so the bottom line of that essay was that we should be guided by our moral principles in our conduct of foreign affairs and in the way we combat terrorism.
And certainly rhetorically and in context it makes sense. But if I understand you correctly, it doesn't reflect your view of the First Amendment and wouldn't be indicative of your jurisprudential approach to First Amendment questions.
That's right, Senator.
Okay. Thank you. I see my time's expired. Senator Whitehouse.
Thank you, Mr. Chairman. Mr. Menashi, do justices on the Supreme Court have an anti-religious bias?
Well, Senator, it's not for me to evaluate the personal motives of justices on the Supreme Court, but I have no knowledge of any justice having an anti-religious bias.
Did General John Pershing execute Muslim prisoners in the Philippines with bullets dipped in pig's fat?
Yes, Senator, I think I would like to clarify that particular writing because it has come up.
Could you start by answering the question that I asked?
Well, I think it's important to provide context because
you can, but answer the question that I asked first. Did it or did it not
Senator,
happen?
at the time that I had written that essay, I had read that anecdote in a number of sources and believed it to have been substantiated. After 20 years, it does seem
You've learned that it's not true and
an
wasn't
adequate
true
factual
then.
basis. I regret having repeated it. But I
Do
want to
trial
emphasize
lawyers do trial lawyers feed on the public?
Well, Senator, if I could just clarify.
Actually, this is my time, so you have a whole world of time to clarify anything you want in the public sphere. I have a very limited amount of time right here to ask my questions. Do trial lawyers feed on the public, and do they not have the public's well-being at heart?
Senator, as I explained to Chairman Graham, what you're referring to is an editorial that was published in the New York Sun, which was about a specific dispute in New York between different teams of trial lawyers. It does not reflect a considered view. It was not written when I was an attorney. I believe in zealous advocacy on both sides, and I have represented both plaintiffs and defendants and think it is important for everybody to receive representation.
Did you laud Christian students at Ohio State University for convincing the university to change its non-discrimination policy to allow the Christian Legal Society to prevent gays from becoming officers?
Senator, I think what you're referring to is, again, an editorial that the New York Sun had written where the
New York Sun wrote it or you wrote it?
Well, as the Senate questionnaire explains, I had, out of an abundance of caution, listed every editorial of the New York Sun in which I might have participated, but I think the letter you had received from the New York Sun to this committee explained that it was always a cooperative effort that developed a view of the paper, so it was not necessarily the view of any particular individual. But I will say that editorial, I think, did say that the Ohio State University policy that provided for accommodation of religious groups that it had voluntarily adopted, the paper did say that that was a welcome development.
And the welcome development was that gays could not serve as officers.
I mean, I forget the details of the specific one, but it was that religious groups on campus, there was additional accommodation for those groups for sincerely held religious beliefs,
including
in the way
that
they
gay
govern
people
their
could not serve as officers.
That may have, like I said, I don't have a specific recollection of the policies, but that may have been what it was.
Are your views on climate change informed by a person named Bjorn Lomborg?
Senator, I am familiar with that he exists and has written on climate change. I have not looked at that question for probably, certainly since being a lawyer. So I don't have a strong view about his views on climate change.
Are you aware that he is a notorious crank?
I, again, don't have a view one way or the other.
Have you compared college affirmative action programs to the Nuremberg laws?
So, Senator, that has come up. It is something that I have wrote in college. Let me be clear. There is no comparison to be made between the Nuremberg laws and any activity that goes on a college campus. I did not believe that 20 years ago when I wrote something in college, and I don't believe that today. Some of the writings I did in college were writing from the perspective that I thought that it was inappropriate to treat people as members of groups rather than individuals, which was important to me because my family had suffered discrimination on the basis of group status. And if some of the writing was overheated or extreme in advancing that view, I regret that implication. But let me be clear, I did not believe then, and I do not believe now, that there is any comparison to be drawn between the Nuremberg laws and anything that happens on
Let me
contemporary
close
college
by
campus.
responding to Senator Lee's comments about the duty of confidentiality. I'm not completely expert on this, but I've litigated these questions in the past, and my understanding is that the fact that you have represented someone is not protected by any duty of confidentiality, nor the areas of advice that you have given them. It is only the substance of the advice that is protected. And so in my view, Mr. Menashi's position that he can't say whether or not he advised his client on the question of family separation is not protected by confidentiality. We can disagree. You said your opinion. I want to make sure that I said mine. Thank you.
Mr. Menashi, what can you tell us about your judicial role models?
Well, Senator, I have several. I was very honored to clerk for two jurists that I've come to admire greatly, Judge Ginsburg, who's here with us today, and Justice Alito on the Supreme Court. I think their devotion to respecting judicial precedent, to putting their views aside and judging cases only on the merits, and in deciding really only the case that is before the courts, because after all, it is the role of the courts to decide specific cases and controversies. Those are all principles I would emulate as a judge.
You're familiar with Hamilton's distinction that he draws in Federalist 78 between will and judgment?
Yes, Senator. If it is the job of the courts to exercise judgment and not will, meaning it is not for the judge to try to achieve a particular policy outcome that he may think is desirable. It is the job of the judge to exercise judgment by looking at the legal materials before him or her and deciding the case independently on the merits.
What happens in the unfortunate circumstance in which the judicial branch exercises will rather than judgment?
Well, Senator, in that circumstance, it undermines the rule of law because it is for the legislature that is democratically elected to determine the policies that should govern our society, and it is for the courts to rely on, to faithfully apply those laws that have been enacted by the people's representatives.
What happens when you faithfully do that is that in many instances you end up with a result that is either counter-majoritarian, in that it's contrary to the will of the majority of the people. In many cases, it may shock the conscience of many onlookers. You may end up with outcomes that people would find patently offensive. Somebody who might, in the minds of most citizens, be entitled to a particular remedy is often left without one. And so in that respect, jurisprudence applied in the way that you've described can lead to a counter-majoritarian result. Is that a problem?
Well, Senator, I think it is The counter-majoritarian difficulty is something that courts grapple with, but sometimes it is the job of the courts, especially in the protection of individual rights, to protect individual rights, even if the protection of those rights are politically unpopular. So sometimes you do face the counter-majoritarian difficulty, but
In fact, that's the whole point of having a constitution that
That's
limits
right.
government.